Good morning, everyone, or good afternoon, or good evening, wherever you are in the world today. Thank you so much for joining us at this town hall, the CCC Town Hall AI and Copyright, Essential Information for Global Cross-Border Business. We're really excited to have you all here today for what is sure to be a really interesting and useful conversation about AI and copyright. So I am Katie Zoller-Rowland. I am General Counsel here at the Copyright Clearance Center, CCC. And today we're going to be really talking about why AI and copyright are an international matter, how they cross borders and how to work with that, and how there are different approaches around the world. So we don't have one world copyright, one world approach to AI. So we're going to be talking about that with people from around the world. And then we're going to be talking about some potential solutions, including licensing to help with harmonization and helping with how to tackle some of these very complicated issues. So we're really excited to talk to all of our experts. I'm going to go ahead and introduce them now. And before I do, I will say we're happy for people to ask questions. So if you want to put questions in the comment section, we'll be monitoring them and take a look for it. So first off, I want to introduce Karen Temple. She is Senior Executive Vice President and Global General Counsel for the Motion Picture Association. And she oversees the association's legal affairs and content protection efforts around the world. She is an expert on copyright in all different kinds of areas. And before she was at the MPA, she was the head of the U.S. Copyright Office, the Register of Copyrights. I'll put a little plug in for the Copyright Office now, which is the Register, not the Registrar, for everyone out there. So the Register of Copyrights is the head of the U.S. Copyright Office. And before that, she worked for the Department of Justice, and before that in private practice, so a long career in copyright. Next, I want to introduce Eleonora Rosati, who is counsel at Bird & Bird and a professor of intellectual property at Stockholm University. She is the editor of the Journal of Intellectual Property Law and Practice. And one of the most exciting things I think about is she's a long-standing contributor and editor of the IPCAT, which I love. And if you haven't heard of the IPCAT, check it out. And she's also written extensively on IP. Next, I want to introduce Atsushi Okada. And he is a partner in Mori Hamada and Matsumoto's office in Tokyo. He works in IP, in technology, data protection, and cybersecurity. And interestingly, and useful for our conversation, he is a member of various advisory committees to the Japanese government. So for the AI Strategy Council and for the Committee for Intellectual Property Rights in the Age of AI. And there are more, but I would be running out of time if I talked about them all. And then last but definitely not least, we have Professor Daniel Gervais. And he is professor at Vanderbilt University Law School, and he focuses on intellectual property law and AI. He has spent many, many years addressing policy issues as he was a legal officer at the World Trade Organization. He was the head of copyright project section at the World Intellectual Property Organization, WIPO, and he was Deputy General Secretary General at the International Confederation of Society of Authors and Composers, CSAC. So in addition to that, he has many, many other accolades. He's a prolific writer, and I will put a shout out to your book, Forever, which is a novel on AI. So if you want to read some fiction about AI, go ahead and find that. I believe it's a trilogy, so I think the first one is out, and so we'll get 2 more on the way. So with those introductions and having this great panel, I'm excited to start it off just talking about why AI and copyright intersect. Why is it an international matter? And we know that creators, they are generating all different types of works every day in, day out, all around the world. And before we just dive into the specifics, I wanted to ask Karen, can you give us some examples how this works with AI? How are creators doing this, and how are they kind of going around the world with their AI creations?
Well, thank you, Katie, and it's a pleasure to be here today. First, I do want to just say a caveat that I'm speaking only in my personal capacity as a copyright practitioner, and I'm not speaking on behalf of either the MPA or its member studios. But in terms of how creators work today, creativity is no longer local if it ever was. I mean, you might, write a book or paint a picture in one jurisdiction, then you mass produce it in another for sale in another jurisdiction, and then you display it in yet another jurisdiction. And that, goes for all types of creative works. In the film industry, especially, you have a situation where you have contributions from hundreds, if not thousands of different people, all contributing to just one work. And that really makes, kind of filmmaking pretty time intensive, pretty complex, and the need to really be able to work across borders. AI can be useful in that it allows creators who are always going to be at the heart of filmmaking to be able to enhance their creativity through AI, to be able to utilize AI technology to try to do some of those rote, time-intensive type things that would allow them to work more effectively and more quickly, and to be able to focus more on their broader creativity. In the film industry, you might use AI technology for things like rotoscoping, which is combining live action and CGI film together. You might use it for de-aging an actor, or color correcting, or deblurring, or removing something that got into the film shot. So those are the types of things that AI can be utilized for in the film industry. And again, that person who is de-aging or deblurring or rotoscoping may be in a completely different jurisdiction than the person who actually shot the film, or the location where the film was shot. And that's why AI and copyright is truly global.
Thanks, Karen. And it does seem like you can have all sorts of things where you have a book created, turned into a movie, shot in different places, so very interesting how the kind of germ of one idea kind of spreads around. And we know that copyright is country specific, but AI, it is global and cross-border. So Daniel, I wanted to see if you could share some of your kind of high-level views of some of the challenges that arise when they're cross-border. We'll dive into a lot of the specifics later, but what do you think we should think about at the outset?
Well, at the outset, what I would say is, if you want to get a bad grade in my international IP class, you use the expression international copyright. What I mean by that, seriously, is there is no such thing. There are international copyright norms, but there is no international copyright. There's about 193 countries that have copyright laws, and you really have to think of it as 193 different titles that all come with little, differences in the way the rights are expressed, the expressions are expressed, and the way that, for decades, rights holders and users of copyright material have been able to make this work. To have a functioning marketplace, in other words, has been through private ordering. So basically licensing contracts and other types of contracts that can cover multiple jurisdictions, multiple rights, multiple languages, and so on. You can split, the copyrights in all those countries in a number of different ways by contracts. It's a very flexible way to solve the puzzle, so to speak.
Thank you. And I think with that, we've talked kind of generally at a high level about this and why there's no one international copyright law, but there are the many laws and the many different ways that copyright can be in the different places. And I wanted to talk a little bit about some of the specifics for now. So talking about how the different approaches are, how the different countries are facing AI and copyright. So Daniel, do you want to give us some kind of high-level thoughts on, or more specific thoughts on what are the rights and what is going on across the world?
Well, before we get to the rights, some copyright laws are very new. Some countries have only had copyright laws for a few years or a couple of decades. But as we know, many countries have had copyright for a very long time, going back to the 18th century in some cases. So this very rich history among the different countries means that there are differences, but also that these laws take time to change, that they're difficult to change. Countries hold on to their tradition, and so that international harmonization of rights and exceptions can work, but only up to a point. Most people, or many people in the call, have heard of the Berne Convention and TRIPS agreement. So the Berne Convention is a WIPO administered treaty from 1971, the last version, and the TRIPS agreement is the World Trade Organization agreement from 1994. And if you look at those dates, they're not just pre-AI, they're pre-internet. If by internet we mean the HTTP protocol that we usually equate with the internet. Now, of course, in 1996, we had two new treaties, the WIPO Copyright Treaty and the WIPO Performances and Phonograms Treaty. So sorry for all these long names, but essentially those treaties did two things that most countries added to their copyright law, which was anti-circumvention provisions, which are basically provisions saying if there is technology used to prevent access or control access to a copyrighted work, then you cannot circumvent it. And they also added making available provisions, the way that material can be made available online, which some countries consider as a new right, and so that's an interesting difference. And other countries consider it's already covered by their copyright law. So since those 1996 treaties, and that's a long time ago, we've really only been able to harmonize exceptions for people with print disabilities and audiovisual performers. So my point here really basically is twofold to summarize. Harmonization is slow in most cases, but second, and perhaps more importantly, there will never be full copyright harmonization. Each country will want to keep some differences. And in fact, there are some deeper disagreements among countries on things like formalities, exceptions, and the way that you formulate exceptions to copyright. So, do you have open-ended like fair use, or do you have specific? So the good news, and I'll end with this, is that the basic rights in copyright law are comparable, right? The right of reproduction we are all familiar with. The right to make copies, basically, the right of public performance, which has different names in different countries, but basically exists pretty much everywhere. And also within the US, we call the right to prepare derivative works, which other countries call differently, also tends to exist in most jurisdictions. So the labels change, the rights pretty much exist. So yes, some harmonization, never full harmonization. And exceptions that vary more than the rights. The exceptions actually vary quite a bit from country to country.
Thank you, Daniel. And with that, I guess we can start going country by country, not all 193, but perhaps a few of them. And I'll start with Karen. So Karen, can you tell us a little bit about the United States? Are there any current laws that specifically address copyright and AI?
Well, no, there isn't like an U.S. AI Act, for example, like we have in like they have in the EU. In the United States, there isn't that specific law that is aimed towards AI, but there are a lot of laws that would currently today impact AI. The biggest, of course, the strongest law that would do that would be the U.S. Copyright Act, and the U.S. Copyright Act really does allow for a very robust framework already that really would, provide the rules of the road, so to speak, in terms of what you should be doing with your works that are created by AI, or how you should create AI works. And so in the United States, we have a very robust framework that is technology neutral. That is, it has been able over the years to grow and accommodate all the types of new technology that comes into existence. And one of the things that really allows us to do that is the fair use exception, for example. And that is something that Professor Gervais mentioned. That's an open exception. It is not a specific rule that says this is okay to do, without the consent of the author or not. It is a framework that is able to be flexible enough to apply to any type of scenario, because it's basically something that is required to be done through a case-by-case analysis. And so the U.S. copyright law is robust enough with the types of exceptions that it has, like fair use, to really be able to accommodate, for the most part, technologies as they are developed.
Thank you, Karen. And you mentioned perfect timing, the AI Act. The EU has an AI Act, and I think Eleonora. So I'm going to move to you here. And what about in the EU? So I would say that a lot of us in the copyright world, or the world generally, have heard about this AI Act, but not much about it, and not much about how it works with AI. Can you give us a little bit of information about that?
Yes, with pleasure. Thanks so much for having me, and apologies for the voice that is different from my usual. So yes, as it was correctly pointed out, the European Union has recently adopted this regulation. It is not copyright-specific legislation, so that I think is an important point, and it sets a number of requirements and obligations for different players in the AI development sector. Having said that, what is interesting from a copyright perspective is that the AI Act has an ambition that is legally relevant to extend the reach of EU law also to situations that might have been undertaken outside of the European Union. And specifically, this relates to the training of AI models. As I will be happy to explain in a moment, the European Union has adopted some specific exceptions for text and data mining, which might be relied upon by AI developers. But in essence, what the AI Act does do is to mandate compliance with EU copyright rules, including text and data mining provisions, and specifically the chance for right holders to reserve their rights so that the exception will not be applicable to their content. Also, when the training of AI models is done outside of the European Union. So to simplify, if I train my AI model in a jurisdiction that I might be perceiving as more generous in terms of uses that can be done without authorization, once I've done the training and I want to bring my model to the European Union and offer it there, then the AI Act does require that all the steps in the process leading to the development of the AI model comply with EU law, including when it comes to the initial phase, input, training, and the undertaking of text and data mining activities. So to conclude, some of those that are following this event might be familiar with the phrase Brussels effect, which refers to the political influence that EU policy and lawmaking approaches might have in other regions of the world. But what the AI Act is to go well beyond this Brussels effect and actually have a legal extension of the EU rules also to developers that are based and train their AI models outside of the European Union.
Thank you, Eleonora. And I think you mentioned text and data mining. And while text and data mining and AI, they're not the same thing, but often text and data mining, or TDM, is used with AI as part of AI. And I know that the European Union has had a TDM exception for a while. Do you want to mention a little bit about that? Because that is something that, so even in the United States, there's no specific TDM exception, but what about in EU?
So actually, in the European Union, we have two TDM exceptions, and they are found in a copyright directive from 2019. And the first exception is meant for specified beneficiaries that are research organizations and cultural heritage institutions, while there is another one that does not have restrictions in terms of beneficiaries. So both of these provisions cover acts of extraction and reproduction, so relating to a specific part of the development of an AI model. And there is currently also a discussion as to whether these provisions will be even applicable in the context of AI. My personal view is that with the adoption of the AI Act, this response might be given already. Having said that, insofar as the second exception is concerned, the one without restrictions in terms of beneficiaries or reasons why text and data mining is performed, there is a possibility for right holders to reserve the doing of TDM activities in relation to their content. So this is a key aspect of the European approach. Currently, there is a discussion on how reservation is to be done, what is acceptable for different stakeholders that are involved in this discourse. And of course, the AI Act does mandate compliance with text and data mining provisions, including the rights reservation. So that is why I said a moment ago that the training that could be considered lawful in a jurisdiction that might be more generous than the European Union might be overcome by the application of EU rules, including the reservation that right holders have done under the EU tax data mining provision.
Thank you, Eleonora. And I think that there's a lot to think about there. There are a lot of different moving parts and the AI and how AI works and the different parts. And I do think it's interesting to kind of harken back to something that Karen said about most of the US law is pretty technology neutral. So it's interesting to see how different countries are handling this. And with that, I want to turn to Atsushi, who can give us some experience from Asia. And how would you characterize the situation in Japan and other Asian countries? Are there any current laws that specifically address copyright and AI?
In Japan, although there is no special law focused on AI and copyright, and we also do not have a general fair use exception like in the United States either, the existing Copyright Act has a data analysis exemption of Article 30-4. That provision was introduced in 2018 before the rapid spread of generative AI, and now has a broad application in the context of AI as well. Normally, the interpretation of the Copyright Act should be addressed by courts in litigations. However, there are currently very few court precedents in Japan that directly address AI and IP issues, and therefore various copyright owner groups raised concerns that the lack of clarity may lead to a situation where their works might be used for training AI indiscriminately without any restrictions. With such concerns in mind, the Japan Copyright Office launched discussions about a year ago by establishing a committee composed of experts, and they finally published their views in March this year. That committee discussed a broad spectrum of issues ranging from the input side to the output side. But the most controversial topic was the input side, meaning the scope of AI training permitted under Article 30-4. So that provision is a flexible data analysis exemption provision, which covers acts that do not aim at the enjoyment of thoughts or sentiments expressed in the work. This exemption broadly covers commercial use and does not grant copyright owners a right to opt out. However, there is still an exception to this exemption, and even the non-expressive use is not permitted if the interest of copyright owners would be unreasonably prejudiced. In this regard, various experts in the committee voiced different opinions and did not reach a perfect consensus, but the final version of the committee's report suggested a possibility that Article 30-4 might not apply in cases where publishers of academic papers or news publishers provide licenses and APIs for text and data mining for their article data, depending on circumstances. Thank you.
Thank you, Atsushi. And I think we at least in the copyright and AI world, we often hear about Japan as being one of the places with a text and data mining exception. And it's interesting to hear about, I think the concept of enjoyment is something that is hard for people who are not familiar with Japanese law to understand. So I appreciate that. And I think that all of those materials, I've seen them online. So if people are interested, I'm sure they can find them. They might be in Japanese. You might have to get some translations working, but there was a really, I think, extensive guidance back in March, as Atsushi mentioned. So thank you very much for telling us about that. So we have talked about the law, like the existing law, what's there now. And I guess the EU AI Act is very new. It was actually just brought into force, only several months ago. But then the question is, do we know if there are other kind of legislative efforts out there? So if there are no laws, or there are laws, but there may be a desire for more, are there any efforts underway in Japan and the US or the EU? So I'll start with you, Atsushi. Is there anything out there in the legislature being proposed?
In Japan, there are not many legislative efforts focused on AI and copyright because so far the government has been mainly focused on clarifying the interpretation of the existing copyright laws. Some stakeholders have been calling for new regulation restricting the use of performance that feature the voices of actors or voice actors, but I'm not sure if that actually leads to a new legislation. Other notable legislative developments in Japan is AI governance in a more general context, apart from IP-specific developments. So far, Japan has taken the soft law approach of respecting AI governance and providing just voluntary guidelines, but various issues remain for future discussion, such as difficulties in monitoring compliance and then also ensuring incentives to comply with voluntary guidelines. And in this regard, the government has recently established a study group to discuss whether minimally necessary hard law regulation should be considered for AI that involves extremely high risk or general purpose AI. At this point, such potential hard law, even if it is codified, is not likely to introduce copyright-specific provisions like EU AI Act, but we need to keep an eye on the study group's discussion. Thank you.
Thank you, Atsushi. And so now we can go kind of across the Pacific Ocean to the United States and Karen. And so Karen, we know that there's no specific AI copyright law, but I know that there's some efforts underway. There's some bills kind of percolating, and then maybe in the States. Do you want to talk a little bit about that?
Yeah, sure. So although there's not a U.S. AI Act, as I said earlier, right now, that doesn't mean that the U.S. government and state legislators as well are ignoring this kind of sea change that AI is bringing to the world. And so there are a lot of efforts to at least review the laws to see whether there needs to be any changes. Are there any gaps? Even though we do, again, have a very strong, robust copyright framework that is technology neutral, are there any gaps that need to be filled? And so, for example, last year, the U.S. Copyright Office announced a public study where they were going to essentially study, I would say, almost every possible aspect of AI and copyright, and they sought public comment. They received over 10,000 comments from members of the public, answering a series of questions that the U.S. Copyright Office had asked. They did roundtables where they had conversations with folks within the creative community as well as technologists about these issues, and they said that they would be releasing a series of reports on specific issues in the kind of copyright and AI space. And they actually already released their first report on the issue of digital replica in July, so just this summer, and they have two more reports that are coming that will really, I think, go into more concrete and deeper analysis with respect to how does AI apply with respect to, or how rather does fair use apply with respect to AI? How does the copyright act accommodate specific uses and specific use situations? Are there any requirements with respect to AI services in terms of having to comply with the Copyright Act before they use, for example, someone's creative work without permission? What exceptions would apply to allow that or not? They're also looking into the issue of copyrightability. So if something is generated by an AI system, which you can do now, and you can put in a prompt, and you can out comes a piece of music, a piece of visual art, a text or a book. Is that copyrightable? What level of human authorship or human contribution is required for you to be able to get copyright protection? So those issues are issues that the U.S. Copyright Office has issued this study. They're going to have something out, I think that they said by the end of this year. So it will be really, really interesting to see what type of guidance the U.S. Copyright Office gives after they've done this kind of really extensive study in terms of where there are gaps. Are there things that they might clarify from the U.S. Copyright Office perspective in terms of what's copyrightable when AI technology is used and what's not? So I think that will be very interesting. There are also, of course, legislation on kind of more narrow issues, both at the federal and state level, dealing with aspects of AI and copyright or AI and other IP. So, for example, there are bills and legislation that's out there on the use of digital replica and what type of permission is required for someone to kind of use your image or recreate your image as a digital replica. And for example, there's a bill out right now called the No Fakes Act that is really supported by a lot of industries that would require authorization before somebody's digital image is used. It provides robust protections for kind of notice and takedown if your image is out there. So there are pieces of legislation out there that address some aspects of kind of all of the AI questions out there. But I think the U.S. Copyright Office reports, the series of reports that will be released this year will be very, very helpful in terms of providing guidance and, you know, kind of just updating the public in terms of copyright and AI in the United States.
Thanks, Karen. I think, yeah, we obviously have a lot of things going on in the United States, and we'll stay tuned and see what happens. And so then, Eleonora, is there anything, not just in the EU, but formerly EU, the UK and what they're up to in the space of potential legislation?
So as I think is clear by now, there has been a legislative influx in Europe over the past few years. When I was discussing the text and the mining exceptions at the EU level, I did not mention that the UK had already legislated to adopt its own TDM exception in 2014. And recently, the UK government considered whether to amend the scope of the exception, and the conclusion was in the negative. So a lot has happened, and right now it is a moment of change for both the EU and the United Kingdom. There have been elections in both systems very recently. Insofar as the European Union is concerned, the new cabinet of commissioners has just been formed. So we shall need to wait and see what is going to happen. So starting with the United Kingdom, there has been indeed this idea of enacting a UK AI Act, but tangible progress is probably still to be done. So we shall see how that proceeds and what points of similarities and differences there might be with the EU version of the AI Act. And then, of course, at the EU level, there seems to be a revived interest for some legislation that was proposed during the previous commission. And here I'm referring to the AI Liability Directive, that is, again, not copyright specific, but it might be relevant also from a copyright point of view, because it harmonizes national laws in relation to liability resulting from torts committed through AI. So that might be one thing. And then if I put my academic hat on, I would say that also at the European Union level, there might be the need to discuss some issues that were also outlined by Karin and Atsushi, and that related to the protection of one's own image, likeness, voice, and so on. Why am I saying so? Because when it comes to image rights or publicity rights or personality rights, as we want to call them, there is no harmonization in the European Union, and the truth is that they are very different from member state to member state. So this might be a topic in which EU harmonization might be considered, as well as greater harmonization of the copyright laws of member states. But again, insofar as this final point is concerned, it is my own speculation. No official announcement have been made in this sense, so we shall need to wait and see what the commissioners in charge of these issues will decide to do and how to orient the policy action of the European Commission. And the same will go for the United Kingdom and the possible UK AI Act.
Thank you, Eleonora. And I think the one last part to think about when we think about how the law is made, in many countries it can happen through the court system. So there are a lot of cases going on, especially in the United States, and we don't have time to go through all 30 plus of these cases, but just to kind of give everyone a little quick insight into it, I wanted to turn first to Karen, because that is where the vast majority of these cases are taking place. Can you give us a very high-level explanation of all of these 30 cases that are happening around the United States.
Yes, that's true. There are 30 cases, and I think part of it is maybe we're a little litigious in the United States, but also I think it is our system. So as I mentioned, we don't have a specific exception that applies to the use of works in AI systems. We have a fair use exception, but that has to be done at on a case by case basis. It's not something where you can unilaterally declare all ingestion is fair use or all outputs are fair use, even though some I think do try to say that's just not the law. The law in the United States requires a specific case-by-case analysis of the fair use factors to determine whether the use, somebody's use of a work without permission is permitted under the law. That means that there are going to be, cases and lawsuits for courts to determine those issues. And right now, yes, there are 30 cases, roughly around 30 cases that are pending in federal district courts around the country, in California, in New York, and Delaware. They've been brought by all sorts of creators. So they've been brought by music publishers, record companies, photographers, and it kind of runs the gamut. There are even class actions that have been brought by authors, attempting to represent a class of authors whose works have been ingested by AI systems. So there's a lot of litigation going on, and I think the court will have, the courts will have something to say in terms of what is a permitted use under, the copyright law, and that does not require compensation or permission with respect to an AI system. The courts will make that decision. The claims that have been brought by these creators, are typically, copyright claims, claims for direct infringement of by the AI systems, indirect infringement by the systems and the users committing a direct infringement. They also sometimes have, other Copyright Act like claims such as removal of copyright information, and then non-copyright claims like unfair competition, and other similar claims that are not specific to copyright, but that are often in copyright cases. So I think it will be very interesting just to see what the outcome is. I will say it will be likely, since this is a new area of law, that these cases will be cited at the district court level. It's likely that they will then be appealed at the appellate circuit court level. And it's possible that we might even have at some point a Supreme Court decision that clarifies the law. But again, under our law in the United States, it's still going to be a case-by-case fact-specific analysis. So even if you have one case that says, hey, it's okay for this system to have used or ingested copyrighted works without permission of the author, another case could come out completely differently. And right now, all the cases are pretty much in the early stages. So we do have to wait a little while before we're going to have that first decision that really goes through that fair use analysis to see what might be permitted or not in a specific case.
Thanks, Karen. And Atsushi, what about over in Japan or Asia?
Well, while there is no major litigation pending in Japan, I am aware that there have been some notable court decisions in China. For example, in February this year, an AI service provider in China has been found liable for copyright infringement and ordered to pay damages over generative AI images closely resembling Ultraman, which is a famous character originating from Japan. In this case, the Chinese court stated that the generated images are a partial or complete reproduction of Ultraman's original depictions, and therefore it must take responsibility for stopping generation of those images. Another notable court decision in China was the one issued in November last year, which granted copyright to AI-generated image for the first time. In that decision, plaintiff generated an image of women by using Stable Diffusion, a generative AI model that creates images from textual prompts. according to the Chinese court's decision, plaintiffs selected over 150 prompts, arranged their order, and set specific parameters, and continued to adjust and modify those prompts and parameters until the final image aligned with the plaintiff's conception. The Chinese court ruled that those steps sufficiently demonstrate that the disputed image was created as a result of plaintiff's intellectual input. So it was a very interesting case.
Thanks, Atsushi. And then I'll ask Danielle. So are there any cases of note you want to mention in the EU or the UK?
Yeah, in the UK, there are at least two interesting cases. So the UK does not have fair use. It has something called fair dealing, which isn't quite the same. There are similarities, but also important differences. So courts will apply a different test. But so the first case is the Getty Images case. That is a case against stability for the model that Atsushi-san just mentioned. Which alleges unlawful copying of, I think it's 12 million images from the Getty database. There's also an interesting case, and I'm not sure how to pronounce it. It's written L-A-I-O-N. I think it's Lion or Leon. Is an image data set, and the artists whose works are in that data set, the visual artists, have also sued Stable Diffusion. So those cases are, basically close parallels in terms of the factual basis to those that we have in the U.S. The law, though, is a little different. The EU, so the EU has no fair dealing. It has no fair use. It has Articles 3 and 4, as Eleonora mentioned, in the Copyright and the Digital Single Market Directive. And I expect, and this is very likely to happen, that there will be at least two cases going to the Court of Justice of the EU, and Eleonora might want to chime in on this one. But the first is, as she mentioned, there's some debate as to whether these text and data mining exceptions actually apply to scraping for the training of large language models. I agree. I think she mentioned that the AI Act seems to be saying that it does, but there will likely be litigation on that front. And also, the AI Act that Eleonora mentioned contains provisions requiring copyright compliance, and I expect the scope of those, for example, the need for an AI provider to make available a, quote, sufficiently detailed summary, unquote, of the copyrighted material that was used. I expect that will go to court. And the last thing I'll mention is that these exceptions, the scope of these exceptions might be challenged at the World Trade Organization someday, because the TRIPS agreement does contain limits as to what countries can exempt from the reach of copyright rights. Under something called the three-step test. And I'm happy to elaborate more, but maybe we don't have the time. Of course, the US, under both the Trump and Biden administration, has blocked the WTO dispute settlement system from functioning. So I wouldn't hold my breath on this one, but who knows if in the future the system starts working, at full steam ahead, and those cases might be brought.
Thank you so much, Danielle. And I think we've seen that there are so many different ways of doing things around the world. And so this kind of begs the question, what do you do? How do you resolve this? So if you are trying to use copyrighted works and you're using AI, what can you do? How can we get to the point where we can reduce friction and make these uses work globally? And for that, I'm going to ask Danielle, no hard task here at all of Danielle, but how could we start helping to solve some of these issues?
Well, they mentioned my first intervention. I think licensing is obviously one good way to solve many of these difficulties that arise from the existence of these different laws. So one of the forms of licensing that, perhaps the most obvious one, is direct licensing, where a right holder, an author, a publisher, for example, will sign a contract with a user, and that contract is typically called a license. In other cases, rights holders will pool their rights into a more collective type model, but even that it means many different things in many different countries. These collective systems can be voluntary, they can be compulsory in some cases, including in the US, we have compulsory licensing. So their licensing essentially, my main point here is it's an extremely flexible tool. You can design, you can update, you don't need Congress to do anything, you don't need the white vote to do anything, you can just negotiate the contract.
Thank you, Daniel. And Karen, do you have any thoughts on this? Any licensing examples that would be interesting?
Yeah, so I mean, I would, really just echo what Professor Gervais said. Voluntary direct licensing is something that we've utilized for decades and hundreds of years in the United States to really navigate the system, and it is a way to provide that concrete guidance when maybe the law could be unsettled on an issue. So you can, if you don't know whether you have permission or whether fair use is going to apply in a specific case, you can certainly get a license and you can ensure that you will have that permission, as opposed to litigating something and not knowing what the outcome of that litigation might be. And so in the United States, voluntary direct licensing is something that, is really robust and something that most creative industries, really support. I think right now there are probably, I think, at least 20 or so deals that have been publicly reported in the United States between AI companies like OpenAI and Meta and, a host of creative industries. I think Condé Nast had announced a deal with OpenAI, Time, Getty Images, Shutterstock, News Corp. So these licensing opportunities are out there and they're actually being implemented right now. Professor Gervais also mentioned, the concept of, compulsory licensing. I think most industries would say that you really only need, and the U.S. Copyright Office in the past has said that you really only need compulsory licensing when there's a actual market failure, where the market hasn't been able to step in and allow for that voluntary direct licensing. Given the types of licenses that I just mentioned are, already being implemented now, I wouldn't think that we would need any type of compulsory licensing. Different industries, might, want to explore blanket license, voluntary blanket licensing of some sort if they feel that might be appropriate. But I think the bottom line is that the existence of all of these deals that are coming out right now does show that there is a marketplace already in existence and that people are utilizing it and industries are utilizing it today.
Thanks, Karen. And it's interesting because of the different kinds. We've got, the compulsory license that you talked about, direct licenses, voluntary licenses, voluntary collective licenses, those that we provide here at CCC. So, there are options and they have a kind of a fit, they say like a lid for every pot, as you would say, for licensing. And with that, I want to ask Atsushi, are there any thoughts you have about licensing in Japan?
Yes, although Japan has a broad data analysis exemption, copyright owners and AI businesses are free to enter into voluntary license agreements to use, for example, high quality, legitimate data for training AI. So even where Article 30-4 applies, the parties are not prohibited from agreeing on license arrangements. Further, as I mentioned earlier, the scope of Article 30-4 is still not perfectly clear, and you should also note that unlike the input side, there is no special provision on the output side. So infringement liability would arise if AI-generated outputs have similarity with and dependence on copyrighted works. In that sense, there are a lot of incentives to negotiate license arrangement between copyright owners and the AI businesses. And there are various potential licensing mechanisms. For example, there could be bilateral agreement, there could be platforms engaged in revenue sharing schemes. And recently, the Japanese governmental committee stressed that the law alone, so regulation alone is not a perfect solution. So technological solution and also contractual arrangements are the key factors to generate AI ecosystem, which is beneficial to all relevant stakeholders. Thank you.
Thank you, Atsushi. And finally, Eleonora, I wanted to ask if you had any insights from Europe about licensing framework and how it might be useful here.
So, as I think it is clear from what Daniel indeed noted regarding the European landscape, the current scope of both the UK TDM provision and the EU text data mining exceptions is untested. There is no court case that has reached the decision stage. So that in turn might mean some uncertainty regarding the proper construction of all these articles of law. So insofar as the European Union is concerned, an issue that I mentioned briefly, but that is also likely, I think, to attract some potential litigation is how the reservation of rights is to be done, what is considered to be effective and indeed potentially enforceable. And then, as I also mentioned, in either case, both the UK TDM provision and the European Union ones are limited to the extraction, reproduction activities at input training phase. So as Atsushi was detailing in relation to Japan, they will not go beyond that if at output generation there is an actionable reproduction. So living with this uncertainty, of course, some stakeholders might consider it appropriate to think of consensual solutions rather than testing the limits of these provisions through court cases and therefore disputes that might be unfolding over a number of years. And insofar as consensual solutions are concerned, as I guess the people in attendance will be aware, in Europe the landscape is quite diverse and also developed. There is indeed a strong collective rights management system. There are different types of licenses that can be sought. And I would also mention, just in passing, in case someone is interested, that in this 2019 copyright directive on copyright in digital single market, there has been somehow the elevation at the EU level of a model, that of extended collective licenses, that originated in the Nordics, so a specific region of Europe. And then now it is a possibility also for other member states. And when looking at the transpositions into national law of this directive, there are some countries that didn't have really a tradition of ECL before this legislation that decided to take advantage of this option under EU law. So to conclude, the scope and the construction of these exceptions is yet to be fully tested. So within this uncertainty, licensing might offer peace of mind and a solution that is workable on a business level for those indeed who develop these models.
Thank you so much, Eleonora. And I think we are nearing the end of our hour together and wanted to give a little time for some questions that we've received. So we've gotten a couple. One of them was sort of answered a little bit by, or a lot, by Karen already. It was about the U.S. Copyright Office. And I'll give a little bit more information about that and give the opportunity for anyone else, maybe Danielle, Eleonora, Atsushi. I don't know if any of you have thoughts about it. But as Karen mentioned, the Copyright Office is undergoing this kind of comprehensive review of all things AI. They were going to issue their findings in 3 parts. The first part has already come out about the digital replicas. My understanding is the other 2 parts are going to come out by the end of this calendar year. So all my luck is sent to the Copyright Office. All I have to say is that I'm sure Karen and I are happy we don't have to, we're no longer there, so we don't have to go through all that. But, Godspeed to the Copyright Office on it. But does anyone else have any thoughts about what the Copyright Office is doing in their report that is forthcoming? I know, Danielle, I'll throw that to you.
Well, the digital replica report certainly, fills a gap. The report on fair use most likely will be, kind of on the one hand, on the other hand type of report, but that does not mean it will not be useful. I think it can do a very good detailed analysis of the 4 factors that Karen mentioned, and then it, of course, will have to be very careful. I don't expect any appellate court decision before, certainly not this calendar year, probably not next calendar year. This litigation is going to take, with discovery and all that. But I think a lot of people will read that report very, very carefully when it comes out.
Thanks, Daniel. And then another question we have is something we didn't really cover too much today, but it's about authorship. And so somebody has asked about, I'm just going to say it exactly how they have, which is a completely AI created work protected by copyright? And if so, who owns that copyright? So I'll preface this with saying no one international copyright law, the typical disclaimer, your mileage may vary depending on what country you might be asking this question in. I'll start with, why don't I start with Karen again? So Karen, what about the United States?
Yes, I think the United States, it's easy, but not so easy in the sense that the United States does require human authorship in the U.S. Copyright Act. So something that is completely generated wholly by a computer wouldn't be protected under the U.S. copyright law. So it wouldn't be protected by copyright at all. And that is something that, through the years, whether it's something it has sufficient human authorship has been reviewed by the U.S. Copyright Office. It's been reviewed by district courts. There was a court case in the 1800s about photography, actually, and whether photography had enough human involvement to qualify as human authorship. And the court in that case, did say that, yes, it did because of the way that the photographer staged the picture and the lighting, and that was enough human authorship to make that subsequent photograph protected by the U.S. Copyright Office. And so that Supreme Court case from the 1800s will really be the Supreme Court case that will guide, I think, us as we, kind of get into more complex, areas of computer plus human kind of combined work in that creates a copyrighted work. The Copyright Office, again, is going to provide, I think, more guidance. They've provided a little bit of guidance already. There's been a district court case in the United States on this issue as well. Again, the cases and the reviews that have gone on in this space in the past have made it very clear that there is this requirement of human authorship. But the question is how much human contribution is necessary. If you do just put in one prompt and you, and something pops out of an AI platform, I think it's pretty clear in most cases that would not be protected by the copyright law. But what if you put in 100 prompts and then you put in more prompts to refine what you're doing? That's where it gets a little bit more complex. So there is a requirement in the US for human authorship, but it does kind of get a little bit complicated once you really start looking underneath the hood and trying to figure out where those gray areas are.
Thank you so much, Karen. And I think we're nearing the end of our time. We only have a few seconds left before the end of the hour. So I want to take this opportunity to thank everyone who joined us today and who will join us in the future. If you're watching this in the future on a recording, thanks to all of our excellent panelists who are all experts here and really appreciate their insights. And I wanted to also let everyone know that at Copyright Clearance Center, we have a copyright.com/AI resource page. Easiest thing to ever remember, copyright.com/AI. And one thing that we're putting out that's coming out pretty soon is we have an article called The Heart of the Matter that has been written. It's already been written. It's by Danielle Gervais, who is here today, Babis Marmanis, and Professor Noam Shemtov, and I guess myself. And it should be coming out soon, and we'll put a link to it on our AI website, and you can see more about it there. But for now, I really want to just thank everyone so much for joining us, for our panelists, and hope to see you at our next town hall.